Hello, friends. Patrick McFarland here of the Liberty Weekly Podcast, coming at you with another episode. This one is episode 71, and it may be found at libertyweekly.net/71. My apologies if that, for those listening to the video version, if that intro was a little too loud. I'm just getting back after a week, so yeah. So it's been quite a week here for me at law school and stuff. I was just finishing up. I had my final trial on Saturday, and that's why I have not been doing Liberty Weekly stuff. I also I submitted my application for the bar exam, and there's just been a lot of stuff going on, going towards graduation here at the end of the month. So I'm really excited about that. Last week was super stressful, and it's still been a little stressful as I'm trying to tie up like all the knots into a nice little bow and check all the boxes. I have 2 finals left that I have to do this week and kind of into next week. So that's, I'm not sure how that's going to bode for the podcast with episodes. I still want to be putting stuff out. But yeah, so that's why I've been absent for a week, just taking care of business on my end, and just put the podcast aside for a little bit because there are more important things than liberty at some point. So yeah, while I was gone last night, there was the monthly State of the Libertarian Union talk show that you'll see on the screen here. I'll put a link to that in the show notes page for you guys listening to the audio version. Here is
our April show, and
sorry for that. Here is the video of that. We had welcome some new members. One, Stephen Clyde of Peace and Liberty podcast, which I appeared on. There was an episode here. Also, Nick from Sounds Like Liberty. I appeared on his show too, and with his wife Liz, and that was great. All fun. Really glad to see the Libertarian Union growing. And like I said, the link to that will be in the show notes page for those who want to go check that out. And I think there are even rumblings of us doing 2 shows a week for the Libertarian, or 2 shows a month for the Libertarian Union. So I'm excited for that. But boy, do I have a return episode for you guys here today. I found this taser case from Milwaukee County, and it's been making kind of some of the rounds on the news cycle, but I really wanted to dig into it because it involves the police tasering a mentally ill man to death in the shower. And yes, that is as outrageous as it sounds, but as many of these situations, the truth and what really happened is quite a bit more complicated. So I thought I would lend some of my legal analysis to lend some of my legal analysis to this problem, these facts in the real world here. And it did take place in my own backyard. So there's fellow legal professionals that are in the same state that I will be practicing in. So I want to before I even get into it, I want to lend my respect to the legal profession in general as a fellow professional. However, getting to the bottom of things and being honest and providing respectful criticism, I think, is important in this case, especially as it bodes for public policy. And I really would like you guys to have a little more knowledge about how the law actually works, because as you'll see in this situation, and when it comes down to it, your hands can be tied as the district attorney. You are bound by oaths that you've taken. You are bound by precedent. And as we'll see in this, it may well be the case, I'll get into the facts, but it may well be the case that the district attorney made the correct decision. However, that decision could be unsatisfying and even unjust just based on the law itself. So you can have your hands tied as a district attorney, and I don't know exactly what's going on. I haven't been studying this or looking at it longer than last night. So for those of you listening to the audio version, I'll get into the facts here before I even get too far. But it was this man named Adam Trammell. I think it was last year or the year before. He was schizophrenic, mentally ill. He was living alone in an apartment, and an apartment complex that was known for housing mentally ill people. And there had been some situations before in which he had been naked running around the apartment building, and the police had been called before. Well, there were some incidents beforehand. Well, on the incident in question, Adam Trammell was spotted naked walking around the apartment building in some kind of fit from schizophrenic delusion, and the neighbors in the apartment building called the police to do a wellness check on him. So while the neighbors called the police, Adam Trammell was naked. He went back into his apartment. He was in the bathroom. His apartment door was closed. He was in the bathroom. He was in the shower. And apparently there were some talks of the water in the shower was overflowing the bathtub and it was leaking into the apartment downstairs. And that was part of what prompted the 911 wellness check call. So essentially what ends up happening is that the police show up. They break the door down because Adam Trammell's unresponsive in the shower. They go into the shower. Adam is standing there. He is wet. He's being covered in water. He's chugging hot water from a bottle, which is very weird. Obviously in some kind of schizophrenic state, some kind of psychotic break episode. And the police are standing there, and there is body cam footage. For you guys who are watching the video version, I will not play it because the audio is very loud and not fit for the show, but you can view some of it. I'm opening, for you listening to the audio version, I've opened a story and from the Milwaukee Journal Sentinel, and it includes the body cam footage. However, that footage is very, very highly edited. So the police officers get in the bathroom. They're trying to engage Adam Trammell. They're calling him Brandon, which is his wrong name. So that probably adds to the confusion. The police are talking to him. He's non-responsive. They reach out to him to kind of like pat him, and he's out of it. He just goes to try and knock their hand away, and then they tase him. And they tase him, and he cries, he hollers a terrible scream, and he falls to the floor of the bathtub, and they continue to tase him. And the body cam footage is edited at this point, but we'll get into, here's the letter, well, for you watching, here's the letter from the district attorney citing his decision not to charge the officers criminally for this incident. And the footage kind of goes through the same thing. Psychotic break. 3 Milwaukee police officers respond. The officers enter the apartment. They observe a person in the shower with the curtain closed and gave commands for him to show his hands. There was no response. Officer Munoz opened the shower curtain to discover Trammell standing in the shower naked. At the time, Trammell was chugging a liquid from a clear plastic jug. Officer Munoz immediately recognized the fact that Trammell was much larger in stature than himself. I'm not sure if that's true based on the video footage. Officer Munoz reported he tried to engage Trammell in dialogue. I'm just going to read this report because the factual summary is astute. But Trammell did not respond, instead just stared at him. Officer Munoz reached in to touch Trammell and try to get his attention, and Trammell's response was to push Officer Munoz's hand away. Not Officer Munoz himself, but his hand away with an open hand, striking Officer Munoz's forearm. Officer Munoz said some of the liquid from the container Trammell was drinking from had splashed on him, at which time Officer Munoz realized Trammell was drinking hot water. Munoz pointed his taser at Trammell, giving commands. Corporal Rollader, another officer there, said he could not understand what Trammell was saying, other than occasionally Trammell said, "Jesus." Trammell did not respond to the verbal commands, and Officer Munoz deployed his taser. One of the probes struck Trammell in the chest. The video shows a probe in his upper right thigh and lower right abdomen. Trammell fell back into the tub, screaming, that is not mentioned, screaming bloody murder. And during the 5-second cycle of the taser, it seemed to be effective to incapacitate him. At the end of the taser cycle deployed by Munoz, Trammell began to get up again, and Officer Munoz deployed a 5-second cycle from the taser again. Munoz and Corporal Rollader attempted to gain control of Trammell through the use of the taser. Trammell fell back into the tub at one point during a taser cycle, and Corporal Rollader tried to handcuff Trammell. Corporal Rollader reported he was not able to get Trammell into a position to handcuff him with his arms behind his back, and ended up handcuffing Trammell's arms in front of him. So they're in this terrible situation where, and we'll get into this. Sorry, I should have framed this. First, I'm going to go through the facts, and then I want to go through why the DA made the decision not to charge the officers. according to the law, criminally according to the law. Then I'm going to get into the family and how the family hired an attorney. And then I'm going to speculate as to what claims the attorney that the family hired is going to make in the civil lawsuit against the police department, which will be paid out by taxpayer funds. Yeah, and then I'm going to talk about tasers a little bit, maybe even before I get into the civil claims from the attorney the family retained. But sorry for that little aside. So, yeah, they're in this terrible situation, and police officers are not mental health professionals, obviously. From a non-aggression, libertarian standpoint, which I'll probably get to at the end again, I mean, this is you have the aggression issue in terms of the water that was coming down into the apartment below. That is aggression. I think you're trespassing on the property of someone else. So there is a case to be made that, you know, maybe a dispute agency would have responded, or some service would respond to prevent the aggression of the water leaking in the apartment. You know, maybe it's the landlord's issue. The landlord has a private security dispute resolution firm that they call, and they have maybe perhaps a mental health professional team responding to the situation. People that know exactly, you know, the type of people that live in this apartment building, because apparently they were mentally ill people living in this apartment building. And perhaps it's the landlord's responsibility, or in Ancapistan, the landlord would have some kind of what is that? When a subscription to a private security firm, and he knows that there's mental health people on the firm that can respond to his apartment for situations like this. That's what I'm speculating. In this case, we have the monopolized service of the police, who, for reasons that I covered in my domestic violence episode, I think that's episode 55 at libertyweekly.net/55, they are immune from market forces. They have legal protection that we'll get into here against liability. Here it is, the Wisconsin statute that protects state actors. That is WisStat 939.45 under privilege. But yeah, so I mean, just a terrible situation. And sorry, I bifurcated the facts again here. But so after the initial confrontation in the bathroom, the officers continue to tase him in the bathroom. He's on the floor. First, they tase him. He's standing upright. He falls into the bathtub. They tase him some more. Trammell was very strong. That's how the officers described him, and I think that's convenient for them. I'm not sure how strong Trammell was, but he is a big guy. I don't think the officers were smaller than him, not much smaller than him, but so at this point, Trammell is thrashing in the bottom of the tub as he's being tased. Trammell continues to resist any efforts to take him into custody and remove him from the residence. While trying to remove Trammell, Officer Munoz was partially pulled into the tub by Trammell. Trammell had his leg over Officer Munoz as Officer Munoz was down on his knees now. Officer Munoz was being held down by Trammell when Trammell put his leg over Officer Munoz. So they're tasing him, and now there's a physical altercation. And I don't want to get into reading all the facts verbatim, but there is a physical altercation. Trammell tries to bite Officer Munoz's arm. The taser is deployed again, not effective. Then Trammell gets a hold of the taser, because if you're being electrocuted, you probably want to reach for the source of the electrocution and make it stop. More taser. So he was tased for about 15 times during this physical altercation. And I believe it's during this altercation or the next one that the police officers break a couple of Trammell's ribs and give him a black eye. So at one point, so there's the initial confrontation. They tase him a few times. There's a physical altercation. Then the police officers leave the apartment and retreat because they can't get control of him. Then they call EMS and other services, and the EMS arrive, and they do another breach of the apartment, and they physically detain him without the use of tasers this time, and they pull him out into the hallway. in which case Adam Trammell begins to vomit profusely because he had been drinking the water. Now he's been tased 18 times, 15 to 18 times, and he's vomiting profusely in the hallway while his heart stops his heart is beating really, really fast, and he stops breathing in the hallway, and he loses consciousness. And when the police take him from the hallway to the hospital, he is dead on arrival. And that is the situation here. And I'll include a link to all these things. I was reading from the DA's report. I'm going to keep reading from the DA's report, but I'll include a link to that so you can read it all in full to get every single thing that transpired that the DA decided to include in the facts. Yeah, so this is where it goes through the vomiting. His breathing began to slow. And the medical examiner discovered that Adam Trammell's body temperature was 103.6 degrees when he arrives at the hospital. This all happens very early in the morning at around 5 o'clock. So he's dead. What do you think caused his death? Well, that's one of the big questions. The medical examiner stated, let's see, here's an evaluation of the taser. Maybe I'll go through that first. So they're trying to determine his cause of death. Here's a section, electronic control device deployment, written by the DA. During the investigation, the Greenfield Police Department downloaded the logs of the 3 tasers. Using the body camera footage from the West Milwaukee officers, the taser logs, and the timestamped display logs, the investigators created an approximate list of the time and number of taser deployments that occurred during the encounter. It was determined that in the span of 10 minutes, the officers deployed 3 different tasers 15 times total. It seems that Mr. Trammell was only received an electrical charge for at least half of the logged deployments of the taser. So he had overt physical reactions. He was screaming. He was not... It says the body camera footage seems to indicate that Trammell was not incapacitated by all the deployments as he continued to struggle with the officers throughout the encounter. It is possible, if not probable, that several of the probes were dislodged while struggling. It's clear that his skin is wet. And, yeah, it was both Officer Munoz and Rollader were questioned as to why they used the tasers, and both indicated that they believed they were dealing with a medical emergency, so we should use a taser, electrocute the person suffering medical emergency, and that medical personnel would not engage with Mr. Trammell until he was under control. So here's the problem is that, so we have a person having a medical emergency. Well, he's struggling with us, so we can't get the EMS to help him until we incapacitate him. And the only way that we can incapacitate him is by overwhelming his nervous system with an electronic charge until he is docile. I don't think a private security firm would handle the situation this way. So there was the autopsy. The Dr. Brian Linnert conducted the forensic autopsy of Mr. Trammell and concluded that the cause of death was excited delirium and that the manner of death was undetermined. The full autopsy protocol is included in the investigative materials, so there's another case file that I don't have access to currently. So the DA relied upon a medical literature called Can Taser Electronic Control Devices Cause Cardiac Arrest by Dr. Douglas Zipes, and another memo that assessed the validity and reliability of, quote, excited delirium as a cause of death when other competing causes are present as well. So it seems that the medical report was inconclusive. I'm not sure. I don't have access to the medical report, but it seemed that Adam Trammell was experiencing some kind of terrible psychotic break. His temperature was 103 degrees. His heart was palpitating very quickly when they brought him into the hallway. Who knows? You know, what was the but-for cause of his death? Was it his Was it his excited delirium, or was it the officers tasing him and overwhelming his nervous system with electricity? I don't know. It could have been both. Who knows? But for the police tasering Adam Trammell, would he have died? I don't know. I would say it's likely that they were the but-for cause of his death. But one thing that the DA has to analyze here is the police training regarding the use of taser devices in this situation. And according to this, he's reviewed, it's from the Wisconsin Department of Justice Defensive Arrest and Tactics Guide for Use of Force, and in particular the use of tasers. This is the page 168 of the manual, describing the procedures to use when responding to medically significant behavior. So it says, if you're confronted with a subject who is displaying behaviors that suggest the possibility of an underlying medical problem, especially an imminently life-threatening one, managing the situation becomes more complex. Your immediate goals remain the same as always, to stabilize the scene and to preserve life and evidence. How you accomplish these goals, however, may change. An important point to remember is that at the center, what you are seeking is not so much a crime in progress, although criminal acts may be taking place, as it is an emergency medical in progress. So the police training is to approach this not as a criminal matter, but as a medical emergency. And I don't believe that they did that. That's just my personal opinion. If you recognize medically significant behaviors, especially those consistent with excited delirium, which would be Adam Trammell standing in the bathtub, non-responsive, chugging hot water, your priority must be the safety of all involved, including the suspect. Criminal prosecution can wait, but the medical emergency will not. If a person is experiencing excited delirium or some other medical problem that is contributing to violent behavior, no violent behavior aside from being provoked. Adam Trammell only became violent after the officers touched him and he slapped their hand away. So if a person is experiencing excited delirium or some other medical problem, your response tactics should be geared to accomplish the following. Avoid increasing the suspect's agitation or excitement. Okay, well, this is just terrible. This is awful, this case. And this happens all the time, man. The real life is not as cut and dry as you would think. And from a non-aggression principle standpoint, this case, from our perspective, is. But so avoid increasing the subject's agitation or excitement. Well, he started screaming hysterically when you tased him. I think that increased his agitation. Minimize physical struggles with the subject. Well, now he's adverse to you because you just shocked his body. Minimize the use of restraints. Get medical care for the subject as quickly as possible. Well, patently, just watch the video. I don't think the police officers followed this. Of course, your first priority is always safety, and your safety, your partner's safety, and the public's safety come first. Notice the public's safety, not the suspect's safety. No individual safety, the public safety, because Warren v. District of Columbia described a wide-ranging precedent stating that the police have no duty to protect individuals. They only have a duty to protect the public at large, and usually that is more amorphous and forgiving. So here's I won't go through all this, but these are the steps. First, attempt to calm the subject using verbal techniques from crisis management. Well, they called him the wrong name. They had the wrong name. They weren't, I don't think they tried everything they could to get his attention to try and communicate with him. Request EMS right away. Weigh the need for immediate control against the risk to the subject. This is important. Weigh the need for immediate control against the risk to the suspect. Yes. So here's the analysis from the DA, and this is the important part that we'll go through. So this is what he based his decision on. I reviewed this incident with two factors in mind. First, did any of the actions taken by officers Munoz or Rollader cause the death of Adam Trammell under unlawful circumstances? So make the distinction here. It's possible that officers Munoz or Rollader did cause the death lawfully, in which case he could not criminally charge them. So this doesn't it doesn't forego the fact that the officers could have been the cause of death. I think he addresses that later, though. So based on the determination by the medical examiner that the cause of death was excited delirium and the manner of death undetermined, I do not believe there is a sufficient factual or legal basis to believe that either officer's actions were a direct or indirect factor in his death. Like I said, I have not reviewed the medical reports, so I don't know. The second question follows from the first. Did the officer's conduct, even if it cannot be shown to have led to Mr. Trammell's death, become abusive at some point in the encounter? I believe the answer is yes. I think the DA disagrees. But the officer's purpose in restraining Mr. Trammell in the deployment of control devices was to secure medical attention for him. They were not acting in a capacity to stop imminently dangerous behavior directed at themselves for others. Okay, so this is a fair assessment, I think. It was to secure although I think it's ridiculous that you would tase someone to secure medical attention for them, but they were not. He's correct to say they were not acting in a capacity to stop imminently dangerous behavior directed at themselves or others. That is astute. Responding as a first-line community caretaker of a mentally ill person who needs medical intervention is fundamentally different than stopping a dangerous person from committing a crime, but in some circumstances, forceful restraint is required. If they reasonably believed, based on their training, that Mr. Trammell faced an acute medical crisis that required attention, they had an obligation to secure that medical attention. I'm not sure about that. It could be true. I'd have to see the authority for that statement. If under the circumstances restraint was required prior to getting the medical attention, then the question is whether the restraint was reasonable under the totality of the circumstances. I would respectfully disagree with that assessment just based off of these steps that we covered. One, calm the subject. Excuse me, that's an important distinction. Calm the subject using verbal techniques from crisis management. First, so I don't think they followed the steps. We went through that. Objectively, the officers were confronted with a very complex problem. That is true. That is very true. Mr. Trammell was naked, wet, unable to communicate, and in an extremely restricted space. The bathroom was tiny. Whether one accepts the concept of excited delirium or not, it is a condition police are trained to look for and taught to treat as a serious risk of death for the person exhibiting those signs. So we should tase him and send volts of electricity through his body to overwhelm his nervous system. Yeah. Mr. Trammell's behavior was consistent with what is trained to be the signs of excited delirium. He was also a physically large person. That's true. And his actions were resistive, at least to the extent that he could not understand what was happening to him or why it was happening. The question of reasonableness necessarily focuses on the number of times the officers attempted to use the tasers, because the physical location of the encounter was so constrained that it only allowed for the presence of two officers, and the fact that Mr. Trammell was wet naked in an acute mental crisis. He could not respond to verbal communication and resisted officers to restrain him. The only reasonable restraint available to the officers that offered a middle ground between doing nothing and escalating force appears to be the taser. Well, you gotta find something better than a taser. I'll get into this, but lots of people die from tasers. And I think there was a UN Council on Human Rights that declared the use of tasers to constitute torture. I mean, torture. And I think it is torture. I think a lot of people, I know police officers have been tased before, but it is not pleasant. It is awful. It's like waterboarding someone. If they did nothing, Mr. Trammell risked serious harm to himself or others, perhaps. If they used a baton, he risked serious harm. That's true. Don't beat him. Traditional arm holds and restraints were difficult or impossible. The tasers were deployed over a 9 to 10 minute period when the officers were in direct contact with him. See, what I don't understand is I think a mental health professional, police officers should never be part of the problem. If you are... I'm going to go off on a tangent here before I get into the legal analysis, but if you're talking to a back the blue type person, it's the same with arguing against soldiers, against the military. Being anti-war is not necessarily wanting, soldiers to die or hating the soldiers. I have pity for the soldiers. I don't know if I hate them. I think they're in a very, very bad situation, and I have pity for them. This is beside the point, but it's not being anti-soldier to say that you want the troops to stay home safe. Likewise, it's not anti-police officer to say that we are asking our police officers to do too much. We're commanding them to do too much. They should not be community caretakers. They should not be fighting drug wars. They should only be coming when we call them, when we actually need them to protect our property. They should not be, out pursuing petty headlight violations or parking violations, and they're monopolized. And from an ANCAP point, I criticize that. But even from a statist normie perspective, that's what I'm getting at with the soldiers argument. From a statist perspective, it's not anti-soldier to want them to be home safe. Likewise, with the police, it's not anti-police to say, hey, maybe we're asking our police officers to do too much. They're way too invasive. They're confronting these dangerous situations without the proper training, in quick life or death situations all the time, without the proper equipment, and approaching the wrong situations for what they're supposed to do. So here's the kicker then when it comes to the DA's analysis. To support a finding of criminal culpability in these circumstances, I would have to demonstrate that the officers intentionally or negligently subjected Mr. Trammell to abuse under the circumstances that were likely to cause bodily harm. Likely is one of the kicker words here, okay? So to support a finding of criminal culpability in these circumstances, I would have to demonstrate that the officers intentionally or negligently subjected Mr. Trammell to abuse under circumstances that were likely to cause bodily harm. The DA thinks that... Oh, that's not the only thing, sorry. He says there's no evidence to support that the officers intended to harm Mr. Trammell. I disagree, respectfully. After he is screaming for bloody murder and yelling for Jesus to take him, after you have tased him 15 times in the bathtub, maybe the initial tase, I don't know. Maybe the initial tase was only meant to incapacitate him. But after you have tased him and he's screaming bloody murder and for Jesus, I think any tase past that point could be classified as intentionally causing him bodily harm. I think there's an argument there. I think the DA disagrees. Well, I disagree. Respectfully so. But he says there's no evidence to support the fact that the officers I don't think there's evidence that they negligently subjected him to abuse. I think they intentionally did it after they tased him and he screamed bloody murder, and they continued to do so. He says to show criminal negligence, I would have to demonstrate negligence to a high degree, constituting conduct that the officers realized created a substantial and unreasonable risk of harm. Well, I think that... and he says, in addition, I believe I would have to demonstrate that their actions were not privileged under Wisconsin Statute 939.45. So I'm going to get into that analysis too, but I don't think that they had criminal negligence here. I mean, in terms of... You're talking about the likelihood. Something, when it comes to negligence, you're talking about the officers acting with wanton or reckless disregard for the danger to human life. I'm not sure, because the use of tasers, they do cause death in some people, but the percentage is low. So they were doing something that they knew had a low percentage of causing bodily harm. That doesn't qualify as being wantonly reckless. I don't think it is negligent. I think they intentionally caused him harm here. But even if they intentionally caused him harm, the DA would still have to prove that their actions were not privileged under 393.45. So even if they intentionally caused him harm or negligently caused him harm, the DA would still have to prove that they were not privileged under the statute. And that is why I agree that the DA made the correct decision here, in saying that there is not enough here to sustain a conviction criminally. Given the laws, maybe the DA might not agree with that, but that is his professional opinion, and that's the opinion. I mean, frankly, I agree with him. I think that you wouldn't secure a conviction under this. Maybe he doesn't like this. I have no idea. I don't know the DA. So, and I don't want to say what I think he's thinking because that is unfair. But he's correct that he would have to show, and here are the Wisconsin statutes. Here's the statute in question that he is referring to. If you can see it on the screen here. 939.45, privilege. The fact that the actor's conduct is privileged, although otherwise criminal, is a defense to prosecution for any crime based on that conduct. The defense of privilege can be claimed under any of the following circumstances. And this, okay, I have a thing to bring up, but so the first one is when the actor's conduct occurs under circumstances of coercion or necessity, so as to be privileged under these statutes. Yeah, that's, that's lacking the mens rea component of a criminal offense. So this is just. These are not just. Sub 3. Actions are privileged when the actor's conduct is in good faith and in an apparently authorized and reasonable fulfillment of any duties of a public office, or when the actor's conduct is a reasonable accomplishment of a lawful arrest. Okay? So these are where the officers are going to get out under. So basically it says when you're a politician or an agent of the state, your actions under good faith, as long as you're in good faith and apparently authorized as a reasonable fulfillment of your duties, then even if it's criminal, it doesn't matter. You're immune from prosecution. Yes. This is what we say when we say that we delegate the right. This is what we say as ANCAPs when we say that we are delegating rights to police officers or the government that we don't own ourselves. As a private citizen, we wouldn't be immune from prosecution just because we're an agent of the state. Likewise, for these officers, when the actor's conduct is a reasonable accomplishment of a lawful arrest, well, that brings a few questions. Was the conduct part of a reasonable accomplishment of a lawful arrest? That's a question. Maybe a question that the DA does not address in this paper or in his report. So, yeah, it's very interesting. I think that so that bodes the question, what is a lawful arrest? What is the reasonable accomplishment of a lawful arrest? Well, in this case, it'd be a Chapter 51 under the Wisconsin statutes, involuntary commitment for treatment. Here's Chapter 51.20. These are the guidelines for an involuntary commitment. That would probably be this. I think this is a civil commitment, so not a criminal commitment, but still, this would authorize the police officers to make an arrest, even though it would be a civil detention. So let's see. I think this is where they would get out under is 51.20 sub 1 A-D right here. If the subject evidences behavior manifested by recent acts or omissions that, due to mental illness, he or she is unable to satisfy basic needs for nourishment, medical care, shelter, or safety without prompt and adequate treatment, so that a substantial probability exists that death, serious physical harm, or serious physical debilitation, or serious physical disease will imminently ensue unless the individual receives prompt and adequate treatment for this mental illness. Okay, there you have it right there. I mean, Adam Trammell was chugging hot water naked in his bathtub. It is atrocious that the police knocked the door down and had to detain him. He was not suspected of a crime. They did, I think there is an argument to be made that they had the authority under Minnesota or Wisconsin statute 51.20 to break down the door and detain him. Under that, I'm not saying that makes it right. You know, ideally, Adam Trammell or his landlord would contract with a private security firm that would have mental health crisis services, especially because the apartment complex was known for housing mentally ill individuals. Ideally, those resources would exist privately, like just like the Detroit Threat Management Center that I've covered in that episode 55, if you'll go through and look through that. But so this would be the lawful detainer that the district attorney is getting at under the statute here. So yes, and so I mean, I disagree with it. It's not satisfying at all, but I do believe that the DA made the correct call according to the law. I think there are arguments to the contrary that could be made. Perhaps I could make them, but the DA has the authority, has the responsibility, in fact, to judge these factual situations, and the DA has his deference to decide whether or not to press charges, and he chose not to because he didn't think that he could sustain a conviction. That's his call. That just goes to the kind of authority that DAs have, the kind of discretion that district attorneys have. And that's why when you go to the courthouse and you have a driving offense or something, you line up and you go talk to the DA. And the DA looks at the factual report and tries to determine, okay, can I sustain a conviction for this? Does public policy serve this? Does the community serve this? Okay, I'll dismiss it because those things aren't met. Well, they have that. And district attorneys are elected. Not to say, you know, the ANCAP in me does not agree with political authority, the myth of political authority, but DAs are elected, so that's the discretion. That's how the state says that, you know, if we elect the DA, then the people have the say. So the DA is representing the people in the prosecution that they want. That's the theory, at least. So I agree with that statement. Let's turn to the family now. Here's the family's statement. They have retained this attorney, Robin Shello, and they are going to pursue a civil lawsuit against the department, which will be paid with our taxpayer funds if they secure some kind of ruling. I think that's possible. And of course, let's see what they're saying. So Robin Shello, the attorney, says the video is a video of a man being tortured to death. I would agree. He was hit 15 times with electricity, Shello said. They kick down the door, they turn right and go into the bathroom. They reach behind the shower curtain and they start tasing him, Shello said. He's naked, unarmed, and he's screaming, "Jesus, God, take me now." I mean, I'd include the video footage, but A, it's awful. It's horrible. And B, it just wasn't fit for the podcast. It's too loud. But yeah, it's terrible. So they retained Robin Shello. Okay, so here's the story of them deciding to clear the officers of wrongdoing. I mean, they didn't even receive, the officers didn't even receive a suspension or a paid vacation. Yeah, so let's see. I think there's more statement. Here's the letter included that I just recounted and reviewed for you guys. Yep. Very complex problem. Maybe we shouldn't be asking our police officers to do this. Here's Robin Shello's website. She seems like a high-flying attorney, honestly. And I'll put my head to the bottom. So here's the bit on the taser. Here's the video if you want to view that. It is, I wouldn't suggest it. Oh, it's just a link to another story. Well, here's a blog post that she made in memoriam for her client. Let's see here. Okay. I'll include a link to all these in the show notes page. In memoriam, it seems that Robin Shello takes a lot of taser cases and police abuse cases. So here's her statement. She says, the police tortured Adam Trammell to death. This was not help. They were not protecting or serving anyone. Naked, cold, confused, alone, unarmed, and in his own bathroom and crying for Jesus to take him, as he needlessly suffered 15 to 18 electrical discharges from police tasers. Attorneys Robin Shello of the Shello Group and Mark Thompson of Gingras, Cates, and Walks are disgusted by this callous indifference to another human being and are in process of filing a civil rights lawsuit. This is a Stanford prison experiment brutally come to life, but the electrocution is real this time. The pain experienced by Adam Trammell was real. The doses of current charging through his body were real, and the screams, the almost inhuman howls erupting from a place deep inside, somewhere beneath all our justifications and rationalizations. Okay, I can't read this. It's too intense, man. That primordial subterranean river of pain flowing from the very core of his being, a place that most dare not look. So, yeah, it's sad. It's pretty sad. All right. And she mentioned the civil rights lawsuit. I can't help but think that it would be under 42 U.S. Code 1983, which is a federal civil action for a deprivation of civil rights. And you can see on the screen there is the language of the statute here. I'll include a link in the show notes page here. So, yes, this is a terrible case, man, and it just highlights all the problems that we see with the current paradigm and the fact that we delegate rights to the government and a monopoly on these types of services to the government. And all I can say here is, I can point out the problems from a libertarian standpoint. It's hard to offer solutions aside from pointing at the problems in the current system, because who knows what the free market solution would be. I do know that free market, corporations would not be shielded from liability in the same way that police officers and government actors are under this privilege. And I can tell you that. I can also tell you that any private security firm that tased a man to death would probably not be getting security contracts after that point. And, the police aren't even the right people to be responding here. If you're a Back the Blue crowd, I would say, hey, you like your police, you want them safe, you want them at home, you want to be safe, stop asking them to fight a war on drugs in our streets. Stop asking them to deal with these dangerous individuals that are only dangerous because alcohol and drug prohibition, or, drug prohibition means that they can't rely on the police. They always have to be armed because they're adverse to the police. And, when it comes to mentally ill individuals, militarized police services are not the ones to be dealing with these delicate situations. They escalate it. You can see how they escalated it here. So I want to leave with this little bit on tasers, because tasers are dangerous, and I have covered this topic in the past. So I'll play a little clip here from my documentary, which I would urge you all to check out, called The Emerging American Police State. It's a Liberation Library 5 episode where I reviewed John W. Whitehead's book, A Government of Wolves. And there's a section on tasers. I would point you and I would urge you to check out the whole video in full. Yes, so I'm sorry this episode went a little longer. It's my first one back after a week, so I think I deserve a longer episode. But at the same time, there's a lot here. There was a lot to unpack in the facts, because these situations are terrible. And this is the reality of what attorneys are dealing with and DAs are dealing with. I think from an ANCAP standpoint, it is cut and dry. But for normies who are caught up in the system, these are terrible ethical and legal quandaries that they're dealing with. And I believe it's all a result of, the inverse economic incentives of the state itself. So here's the bit on tasers anyways. I hope the audio works for you. So moving on, another theme that Whitehead expresses concern for is the rise of quote-unquote non-lethal compliance weapons that actually are lethal in some situations. And he argues that the use of these quote-unquote non-lethal compliance weapons that are very barbaric, I think, in some situations, actually means that they will be used with impunity because those using them perceive that they are non-lethal.
Now, there's a whole range of different sorts of non-lethal weapons, some of which are obviously available now, some of which they're developing. So you've got traditional things like pepper spray, OC spray up the top there, or tasers over here. The one on the top right here is actually a dazzling laser intended to just blind the person momentarily and disorient them. You've got non-lethal shotgun rounds that contain rubber pellets instead of the traditional metal ones. And this one in the middle here, the large truck is actually called the active denial system, something the US military is working on at the moment. It's essentially a big microwave transmitter. It's sort of your classic idea of a heat ray. It goes out to a really long distance compared to any of these other sorts of things, and anybody who is hit with this feels this sudden burst of heat and just wants to get out of the way. It is a lot more sophisticated than a microwave oven, but it basically is boiling the water molecules in the very surface level of your skin. So you feel this massive heat and you go, I want to get out of the way. And they're thinking, well, this will be really useful in places like where we need to clear a crowd out of a particular area if the crowd is being hostile, if we need to keep people away from a particular place, well, we can do that with these sorts of things. So obviously there's a whole range of different sorts of non-lethal weapons we could give military personnel, and there's a whole range of situations where they're looking at them and saying, hey, these things would be really useful. But as I said, the military and the police are very different. Yes, you don't have to look very hard at this to recognise the fact that they might be very different. But they don't ever get used like that. They get used out in the real world, like in Texas, like this. I confess this particular case was actually one that piqued my interest in this. It happened while I was working as a research fellow at the US Naval Academy, and news reports started coming up about this situation where this woman was arguing with the police officer. She wasn't violent. In fact, he was probably 6 inches taller than me, and she was about this tall. And eventually she said to him, well, you know, I'm going to get back in my car. And he says, if you get back in your car, I'm going to tase you. And she says, oh, go ahead, tase me. And so he does. Yeah, and it's all captured by the video camera running in the front of the police car. So, you know, she's 72. And it seemed that this is the most appropriate way of dealing with her. And other examples of the same sorts of things with other people where you think, well, is this really an appropriate way to use non-lethal weapons? Yeah. Police chief fires taser into 14-year-old girl's head. She was running away. What else was I supposed to do? Or Florida. Police tase a 6-year-old boy at elementary school. And they clearly learnt a lot from it because in the same district, police reviewed policy after children shocked. Second child shocked by taser stun gun within weeks. Same police district. Another child within weeks of tasering the 6-year-old boy.
When you're carrying a hammer, everything looks like a nail.
In the United States, it happened in Canada as well. And a colleague of mine sent me this one from London. But my personal favourite of these ones, I have to confess, does actually come from the United States. Officers taser 86-year-old disabled woman in her bed. I checked the reports on this one. I looked at it. I was really surprised. Apparently, she took up a more threatening position in her bed. I kid you not. That's exactly what it said. She took up a more threatening position in her bed. Okay.
Malika Brooks, 33 years old, 7 months pregnant, was driving her 11-year-old child to school when she was pulled over for allegedly speeding. The police told her she'd been speeding and gave her a speeding ticket, and she looked at the speeding ticket and the cop said, you have to sign the back of the ticket. Well, she said, that will be admitting guilt. I really can't do that. I'll take the ticket, but I can't sign it. The policeman said, you either sign the ticket, lady, or I may have to take you to jail. She refused. The first cop called a second cop in who told her that if she didn't sign the ticket, she would go to jail. A third policeman was called in as backup at that point, who told her if she did not sign the ticket, she would be tasered. He showed her the gun, flipped it around like a cowboy, showed her how it would stun her. She grabbed the steering wheel, stood her ground, refused to sign the ticket. She informed them, she said, I'm pregnant. In 60 days, I'm going to give birth to a kid. The cop said, well, we're going to have to taser you if you don't get out of the car. We're taking you to jail. She held onto the steering wheel. At that point, the 3 cops actually discussed in front of her what they were going to do to her. They said, where should we taser her? First, all of a sudden, they tasered her in the thigh, they tasered her in the side, and then they tasered her in the neck. She falls out of the car onto the pavement at that point. They push her face down and put handcuffs on her back, pick up this pregnant woman, and take her to jail. Well, this lady wasn't going to let this stand, so she went all the way up to the Ninth Circuit Court of Appeals, the Federal Court of Appeals, arguing that this was excessive force, and these cops, she said, should give her some damages for what they did to her, violating her rights, tasering her for a minor speeding violation. The Ninth Circuit Court of Appeals ruled, yes, this is excessive force, but they ruled the police have qualified immunity even when they use excessive force against American citizens.
Okay, and that's what I was talking about with the Wisconsin statute, by the way.
They can't be fined, they can't be in any way reprimanded. She then appealed to the Supreme Court, and as you might expect, the Supreme Court refused to hear the case and let it stand. Being tasered is no light thing. For example, watch this scene here of someone being tasered. Taser. Incredibly, since the year 2001, over 500 people have died from being tased by the police.
Those are not, that's not a current stat.
In a 2008 report, Amnesty International reviewed hundreds of deaths following taser use and found that 90% of those who died after being struck with a taser were unarmed. In late 2007, the United Nations Committee Against Torture declared that the use of tasers constituted a form of torture. More and more people are being tasered. Let me give you a few examples of people who have been tasered. In Florida, a 15-year-old girl was tasered after being taken off a bus following a disturbance. In Arizona, a runaway 9-year-old girl was tased as she sat in the back seat of a police car with her hands cuffed behind her back. In Oregon, police tased a blind and partially deaf 71-year-old multiple times in her own front yard. In another instance, a Florida woman, 12 weeks pregnant, was tased after refusing to submit to a strip search at the jail. She spontaneously miscarried 7 days later. In Texas, a 72-year-old great-grandmother was tased after refusing to sign a speeding ticket. Yet despite all the evidence, the police are using tasers more and more. In fact, the tasers are getting more streamlined and more invasive. There's now the X12.
Okay, this is outdated, but I mean, let's go back and through this footage of someone being tased.
2, 1.
Okay, so as a police officer, you're responding to a man in his bathroom who is unresponsive, who you suspect is exhibiting signs of excited delirium, which could be deadly, and your training tells you that your number one priority is to calm and restrain the suspect. Well, to calm the suspect, rather. Right here, attempt to calm the subject, number one. And your response is to tase him. Let me play this again. There is someone suffering from excited delirium, and your response is to subject them to that. Yes. All right, so I'm going to leave you guys with that, and hopefully my legal analysis has brought a deeper understanding of this subject to you guys. I really think it's important that the public know exactly what we are referring to when we talk about these statutes and when we talk about, making these decisions, and to know that the legal framework in place, this qualified immunity, this government actor immunity, delegating rights to government actors that we do not own or possess ourselves, is the crux of this rot in society and this police state that we live in currently. All right? So, I want to let you know that the Liberty Weekly podcast is back. I'm going to be trying to put out more content going forward. I'm going to start studying for the bar exam here in a few days or a few weeks, and I'm really hoping that I'll be able to, really focus on the bar exam, but that it will free me up to do Liberty Weekly stuff on the side too. And so it's looking to be a really good summer, a really busy summer full of a lot of personal changes for me. I'm excited to see how it will go going forward here. So if you want to help support the Liberty Weekly podcast, you know how to do that. That's at libertyweekly.net patreon.com/Liberty Weekly. You can subscribe to support the show. You get access to tons of bonus content like my meme cache and the Rothbard repository, an indexed and searchable audio repository of Murray Rothbard lectures put together by Daniel from Actual Anarchy. Also, cryptocurrency. I'm going to put a link in the show notes page for all my crypto addresses. I've started trading a lot more in the last few days, and it's brought me some prosperity. And I made my first crypto purchase of Vin Armani's book, Self-Ownership, which I don't have on me right now, but I wanted to read, and I was going to see if I could invite him on the show, and I think that would be really great. So cryptocurrency, don't forget libertyweekly.net/Amazon for all your Amazon purchases. It'll take you right to the homepage where you can do your Amazon shopping and support the podcast with a small stipend from that. So yeah, also show notes page at libertyweekly.net/71. Check out the Libertarian Union show, which will be in the show notes page that came out just this weekend here. So I think that's everything. I'm looking forward to doing more shows like this with concrete legal analysis, especially since I'm done with law school. I'm graduating. I got my JD. So it's been 3 years. I can't believe it, man. It's great. And likewise, I had my final trial on Saturday. Sorry to continue here. But we killed it. Me and my partner, we killed it. We recovered 99% of what we asked for, which was $128,000. We asked for $332,000. We got $328,000 for our client in a personal injury action. The jury was eating out of our hands, was eating our talking points, and awarded us 1% responsible for the accident, while the defendant was 99% responsible. And this it wasn't a real case, it was practice, but I've been working on it all semester since February, and felt really good just to go in and crush it. I gave an incredible opening statement. I killed it, and the judge said it was the best that she had heard in 9 years of doing this case, of everyone doing the same case, that I gave the best opening statement. So I'm not doing that to gloat, but I feel like I deserve to be proud of myself. So thanks you guys so much for listening to the Liberty Weekly podcast. I really enjoy doing it. I missed it over the last week, and I hope that you missed it as well. But there's more good content coming. So thanks so much, and we'll see you later this week.